Sometimes we see this in criminal matters that there were three eyewitnesses seeing the same incident. So prosecution has dropped two eyewitnesses or one eyewitness. In that situation, defense counsel takes the defense before the court that as the prosecution has dropped this particular eyewitness, it makes the story of the prosecution something fishy, and the adverse inference has to be drawn against the prosecution by the court. Question arises that whether in these situations when the witnesses have been dropped by the prosecution, can the adverse inference be drawn against the prosecution? The answer to this question is no, because as per the law, it is completely depending on the prosecution to examine the witnesses they want to. They have absolute liberty for that. Court cannot direct them to examine the number of witnesses they want to examine, because in India, what we follow is the quality of the witness and not the quantity. So if there is only one witness and the prosecution has not examined that, in that situation, adverse inference can be drawn against the prosecution. But if in relation to prove the same point, there are multiple witnesses and prosecution chose some of them not to examine, then adverse inference against the prosecution cannot be drawn. And the landmark judgment for this is Samant Singh versus State of Punjab, 1976 Supreme Court. See you tomorrow.